All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Saturday, April 6th, 2024. We're going to be operating off of voting list number 29. But before we get to that, we've made some of our members who are stuck in traffic. We're going to start off with some concur, not concurs.
SB 429, Shamari, do you want to start with that one? That's
As passed by the Senate, Senate Bill 429 repeals uncodified provisions of law known as the Maryland Vestry Act governing the Protestant Episcopal Church Diocese of Washington and codifies similar provisions. The bill, as passed by the Senate, also requires the State Department of Assessments and Taxation to study the effects of potentially repealing certain provisions of law relating to the United Methodist Church. That was a floor amendment from Senator Muse. The House amendments removed that required study.
This is your bill from the.
no, this is Bailey's.
I mean, we didn't do it. Tell me again and make sure that what I got is what you're saying.
Yeah, so your floor amendment was added, which required SDET to study the potential of repealing provisions relating to the Methodist Church that they have to hold their property in trust.
Right.
The House struck that from the bill.
And did what?
That's it. They just took that out.
No, I don't want it out. I want it in.
Well, the concern here is we're about 24 hours away from Sine Die.
They've had it long enough. And all day today, we will either be concurring or we will.
You don't want to concur.
That's what I'm saying, but we will be doing both all day long. So they have time to do that for that. They have time to do it for this.
Can we do a conference committee with Senator Muse and me on the conference committee?
Right.
And Senator Muse will call the conference committee so we actually meet.
Right.
And we will either reach a meeting of the minds or we'll have to.
Yeah, they can do a study of any sort, but we can't. What they said, they were sending a letter. Well, that's not what I want them to do the same thing for the United Methodists that they're doing for the Episcopal Church, because pretty much it's all the same. It's the very same request that's being done. And so for whatever reason, they decided to cut the Methodists out. You can't say it's good for one and not good for the other. And so I want to push that for the study.
So put Muse West and Kelly on the conference committee.
Actually, I don't want to speak.
You
probably.
Yeah. Put McKay.
You do?
He does.
Church.
I know you want
So-
the conference committee so
I wouldn't mind volunteering. I mean, obviously it's the will at whatever you guys want, but I actually do know a little bit about it. So at least the amendment part.
All right. Muse is the chair, Senator West and Senator McKay. Senator Walstraker.
Yeah, I was just going to add in, like, when we have, to be honest, the issue that you're addressing is not particularly important to me, but it's important to you, and we stick by members of our committee, and that's what we should do in this committee.
All right, what's the next bill? We're doing concurs, not concurs.
All right, House Bill 404.
Sorry, we're doing concurs, not concurs. That was the Archdiocese bill.
Oh, that's recede, not recede.
Yeah.
So, yeah, this is the work zone speed cameras bill. The House did not concur with Senate amendments.
Let's go to conference. We're really close to talk to the chairman of E&T this morning. Very, very close. So we'll very, very close. So we just need to. That's right. There are a couple small things. I think we're very close. We'll go to a conference.
Is it the EMS part of it?
No.
Okay, that part.
No, so
Thank you.
I'll be on that conference. You want just Folden? Who else? You want to be on it with me, Charles? Sure. All right. So the three of us will be on it. It's close.
So as passed by the Senate, Senate Bill 134 establishes the Office of the Correctional Ombudsman as an independent unit of state government and also transfers the Juvenile Justice Monitoring Unit from OAG to the new independent unit. The House amendments did several things. First, they limited the authority to distribute justice reinvestment funds to the office to apply to fiscal year 2025 only. They allow the office to investigate a complaint even where the complainant is not personally affected. It increases from 30 to 45 days the time that an agency has to respond to a report by the office, and it alters the purpose and membership of the Correctional Ombudsman Advisory Board.
So the biggest thing there is the funding source, which they limited to 1 year, which was an agreement reached from the sponsor, GoCap, and the chairman over there. They worked it out, did good work. So they're going to find a dedicated funding source for outlying years, but it's funded for 1 year. My question is for the JJMU, did they keep subpoena power? Did they keep
Yes.
exec noms?
I don't think that's in there.
For the reappointment?
No.
For exec nom? It's not. Does it require a reappointment?
I don't think they have this version changes. I think it's just the governor picks them.
Well, that's next year's problem. All right. So I motions to concur. Is everyone okay? All right. So
Senate Bill 345, as passed by the Senate, this bill establishes the Vision Zero Advisory Commission to advise the Department of Transportation on best practices to eliminate deaths and serious injuries on the roadways. The House amendments strike provisions establishing the commission and instead establish standards and requirements for the implementation of the Vision Zero program.
This is agreed to by all parties, and so my motion would be to concur, Mr. Chairman.
it's been a motion by the vice chair. It's been seconded by Senator McKay. Is everyone okay? All right, great. What's the next one?
Senate Bill 840, Josh.
As passed by the Senate, Senate Bill 840 establishes that automatic license plate reader data captured by a law enforcement agency is the property of the law enforcement agency and may not be sold for any purpose or accessed by a contractor without authorization. The House amendments conform the bill to the cross-file, to House Bill 1081, which has already passed the Senate.
Motion to concur. Second, everyone's okay?
House Bill 404 is the cross-file to Senate Bill 190, which pertains to wellness checks and requirements for those checks. The Senate conformed House Bill 404 to the Senate version, which contained a number of exceptions in the bill. The House refused to concur in those. And just a refresher for the committee, the House amendments provided for wellness checks to be provided by law enforcement agencies as well as fire and EMS.
Yeah, would you repeat that? I apologize.
So the House amendments, the House bill required wellness checks to be performed by law enforcement as well as fire and EMS.
EMS.
Not concurring.
Yeah.
And it would be
can't.
to not receive.
Yeah, there's no way I can get the volunteers to do that. They're not trained for that. I mean, you're literally throwing people to a situation.
Could you the volunteers?
But even is paid firefighters trained in that? To do well checks? You're gonna go to a place where it's possible somebody is. It needs to be law enforcement or social workers.
I'm on it because reached out to me and asked me if I could help her.
Seven, this is the bill that pertains to positive community feedback. The House amended on its amendment to provide that it couldn't be solicited by the police officer who's the subject of the feedback. That's consistent with what the Senate just adopted.
You heard the sponsor of the bill on the floor yesterday, so motion to concur. Is everyone okay? All right, great.
All right. House Bill 105.
So House Bill 105 was amended by the Senate to include provisions relating to the expungement of probation before judgment for drunk driving offenses, as well as ignition interlock requirements. The House did not concur in those amendments and has asked the Senate to recede.
So wait,
Is what they would have been able to do with the bill would have just been to concur or not concur with the amendments. They couldn't have amended it any further. So they're just telling you that they don't want the Senate amendments.
Okay,
So
gotcha.
committee, who wants, so you'll be chair. Oh, wait, yeah, you, Muse, God, you're on 3 conference committees. So you interlock. Okay, so you and Sidnor? You,
Whatever you want.
who,
Probably should be, me and you should both be on it.
yeah, for sure. Okay, because you do, yeah, okay. So you
don't technically.
you don't have to, but Folden, Muse, Wall Striker's chair. Okay, got it.
SB 166.
SB 166 conform the bill to what the House did for House Bill 256, which is to instead of doing a work group, require the Maryland Department of Emergency Management to study issues and factors regarding the feasibility of establishing a waterway incident notification system. So that would be consistent with what the Senate has already passed.
Motions to concur, is everyone okay?
And the last one is Senate Bill 380.
Is that you?
Yeah.
the governor. These two are already on there. One representative of the FOP, one representative of the NAACP. New members would include one representative with expertise in human resources, one representative with expertise in police practices, one with expertise in police retention and recruitment, two citizen representatives.
What does that mean? You have expertise in police retention and recruitment. How does one gain that credential?
Call that group of people that are like the,
Consultants.
but it's like the old chiefs, Hilda, that, you know, the old retired chiefs, they're like the experts.
Okay.
Anyway,
I'm in.
there are people that have worked to be experts in how to retain. So it makes sense. It's not.
Cool.
Or there also could just be people that were good at their jobs that when they did do it with human resources.
All right, concur, you want to concur? Motions to concur, is everyone okay? right.
Never remember any name.
Senate Bill 728 is identical to House Bill 531, which the committee voted favorably yesterday. The bill repeals the requirement for the parole commission to assess a monthly $50 fee as a condition of supervision for each individual on parole and supervised by the Division of Parole and Probation, and the authorization for the division to require an individual on parole and supervised by the division to pay for drug and alcohol testing ordered by the parole commission.
It's been seconded. Is everyone okay being recorded in the affirmative? It's the, what was the house, what was the? Yeah. We're just moving Jill's bill as a cross file of it. All right. All right, so that passes unanimously. All right, we're now gonna go, all right, to House Bill 137. I see Delegate Grammer's over there. I used to call him Red Robin when we were in the House because he used to wrote red on everything. And now I'm gonna call you Delegate Toaster because you're popping up all over the place, man. All right. All right, so House Bill 137. All right.
Oh, man, come on, man.
House Bill 137 provides that a member of the administrative, educational, or support staff of any public, private, or parochial school acting in an official capacity is not civilly liable for personal injury or property damage resulting from intervention in a student altercation or other student disturbance if the staff member intervened in a reasonably prudent manner and the actions taken do not constitute grossly negligent, willful, wanton, or intentionally tortious conduct.
The only thing I want to make certain that I'm clear on is if a fight breaks out, the teacher intervenes, and I want to hear from counsel that if that teacher does something beyond just trying to stop in the fight, that we're not giving them limited, right.
The bill accepts intentional conduct. I'm just trying to find the exact language within it. Right. They have to act in a reasonably prudent manner, and the actions cannot be grossly negligent, willful, wanton, or intentionally tortious. My reading is that it could be negligent.
It's just an asking the sponsor. Is there a reason why you chose grossly negligent rather than negligent? Delegate. We don't touch the mic in judiciary. Do we do it here?
Yes.
Yeah, so great question. It's the question. This bill's been worked on for several years, and this issue was initially discussed with the original bill sponsor and the Association for Justice. And the Association for Justice was the party who asked for the amendment, which added this language the gentleman has mentioned to the bill. So I think that governs most of the behaviors that we're looking to cover. And I guess the question.
Grossly negligent is different from negligent.
Correct.
So I'm just curious, do you know why?
Yeah. Well, grossly negligent, I mean, that's clear why that's made part of the bill. I
Right.
think the question that you're getting at is negligence.
Right.
So if one student is trying to swing a chair at the other and I block the chair and I scratch the gentleman, is that negligent?
No.
I think that's the behaviors that are trying to be sussed out here. And we talked about that a little bit. And that's why we gave some wiggle room and we accepted the amendment from the Association for Justice as they asked for it.
Okay, thank you.
Thank you.
They got something in there. All right,
All right, thank you very much.
Thank you so much, everybody.
Thanks.
We got some bills over there. Yeah.
I got you,
I shouldn't have said that. He was everywhere though. He was popping up everywhere. He was popping up in the bathroom, popping up in the elevator, like we're popping up in the garage. Like where is this guy?
Yeah.
Let's go. It's House Bill 1227.
House Bill 1227 alters the types of elements and units for which a council of unit owners is required to maintain certain property insurance and limits instances when an owner of a detached unit within a condominium is required to carry homeowner's insurance on the entirety of the unit. There is an amendment. Give me 1 second. I got the amendment. Yep, so the amendment allows a council of unit owners to carry insurance on the entirety of all detached units located within a condominium that has all detached units, instead of just requiring the owner to carry the insurance on a detached unit.
Amendment's been moved and seconded. All right, now the bill's before you as amended. Further discussion. There's been a motion to move the bill. It's been seconded. Is everyone okay being recorded in the affirmative? All right, I know he's not here. So I think Senator Charles has the cross file of that. Is that right?
Yes.
All right, let's just move that bill as well.
Senate Bill 1015.
Yeah, will we have to adopt the amendments as well?
Yes.
Yeah, we can move to conform.
Okay,
Yeah, that should.
that's right.
would adopt.
Just give me 1 second.
Okay.
I gotta go back.
Okay.
And then what was the bill number? Senate Bill
The Senate bill was
1015?
1015, yeah.
Okay.
Jamie, your Senate Bill 115 or House Bill 115? Yeah. I want you guys, when we're doing this, can you, and so for Bill, and
House Bill 115 is the cross file to Senate Bill 4, which the Senate passed. As passed by the Senate, the bill requires a commitment unit to include the name and telephone number of the lead victim services employee of the appropriate state's attorney's office in a specified required notification given to a victim, victim's representative, or witness regarding the release from confinement of a sentenced defendant or child respondent. And there were no substantive amendments to the Senate bill, and they are, let me just make sure here.
And then, I do want to do the Morse's burning.
The House did amend their version of the bill.
It's 115, so it's,
Mhm.
what do they do?
They changed it to the Maryland Crime Resource, Victims Resources, so.
Right.
It's fine.
So it's, do you want to go ahead? What the House amendments provide is that when a defendant or child respondent is being released, the commitment unit shall include in the required notification the telephone number of the Maryland Crime Victims Resource Center.
I know. All right, so you move it, all right, it's been seconded, is everyone okay being recorded?
And it's favorable,
It's
we're not
favorable.
amending
Thank
it,
you.
correct?
No.
Correct sentence.
Yes, that's correct.
Senate, or sorry, House Bill 1258 requires the Register of Wills of each county in Baltimore City to coordinate to establish and maintain a centralized website for use by all registers of wills to publish notices as required under the Estates and Trust article. The bill also requires publication of specified notices on the centralized website instead of publication in a newspaper or of general circulation in an appropriate county. Specifically, notices of appointment of a personal representative of an estate, judicial probate of an estate, appointment of a foreign personal representative and estate information, and a meeting for distribution of the net estate by the court.
Motions for favorable, anyone? All right, seconded by Senator James. All right, is everyone okay being recorded in the affirmative? Okay.
House Bill 282 authorizes a technician employed by an agency rather than only a duly authorized law enforcement officer to sign a statement and a citation alleging a speed monitoring system and swear to or affirm for evidentiary purposes that a speed monitoring system violation occurred after inspection of a recorded image. However, this authorization only applies to a municipal corporation that does not maintain a police force.
Yeah, I know.
Okay.
Is there any discussion? Motions for favorable? I'll second it. Is everyone okay?
No.
All right.
HB 282?
Yes.
Yeah. Okay.
All right. Senator Fulton is down. Everything else good. Okay. Senator McKay is down. Sure.
Why? Because we're taking, this is the bill about the speed cameras, and letting
That's
civilians
right.
do the interpretive measures and issue out citations. They haven't been. Yeah, not all.
Well,
They want to make it.
They are-
So I want you to just talk about the amendments. Who, yours.
Right, so
Yeah,
what
so-
the bill does is said so under current law, only a sworn law enforcement officer may review and issue the citations. So what the bill says is for municipal corporations that do not maintain a police force, they can use a technician employed by the agency that issues the citations. So the current practice is for these municipalities that have speed cameras, they contract with a law enforcement agency outside of the jurisdiction to do this.
I have a question about that then, because I know that Frederick Police Department does these for Newmarket. So what you're telling me is that currently they're not supposed to be allowed to do that?
No, currently they are. The current law is only a law enforcement officer may do it. So if you're a jurisdiction that doesn't have a law enforcement agency, you have to contract someone outside of your jurisdiction to do it for you.
Correct. And then this bill would change it to be not a law enforcement person at all. It could be anybody that's works for the municipality.
Correct. Though it would only apply in those municipalities that do not have law enforcement
So-
agencies.
So it becomes a bit of like a money grab opportunity again, because we're going to not limit them on how many they can put up. They can do it on their own. They're not required to have law enforcement.
Right. They would be able to.
I'm not
to have-
asking you to confirm, like with what I said. I'm just saying like they don't need a law enforcement officer. Currently you do. And that's the whole reason behind this. So now you're going to have uncertified people that haven't been through an academy, through the understanding of and they're going to be issuing it off of their opinion of what they saw. And that was one of the concerns I had even for the bus lane bill when we were talking about it, because same type of thing. You're going to have people looking at it that aren't certified law enforcement. And then is it in the key element in any crime or offense is the intent. And like the intent of these people, if they're pulling over to drop somebody off in the spirit of the law or in the letter of the law, they're in violation. But in the spirit of it, they shouldn't be. But now we're leaving that in the hands of someone that would be a city employee, not accountable to anything and accept their pulses.
You know, I shared your concern, Senator Folden, and I did a little research. And I looked at the testimony and I would appreciate if council could back me up because I don't want to misremember what I looked at, but there was one or two areas already in statute that allowed for non-law enforcement to do the same thing this bill is. It's limited. And then I asked the proponents of the bill, and maybe this should be in the bill, I don't know, but they said, look, people, they have to be trained. You know, there are standards for, you know, checking this equipment and making sure it's accurate. And so they said they're not pulling back from any of that. Now, I think that's correct, council, but that's what my research and discussions picked up.
Yeah, so I believe there are a couple of types of automated enforcement. I don't know which ones off the top of my head that have a similar kind of construction for jurisdictions that don't have a law enforcement agency. Yeah, and as to the training, there's nothing in the statute, but I believe we did have testimony that there's some kind of training. I don't know exactly what it is. No, there is not.
That was my question and my concern. I'm happy to have someone who's not a law enforcement officer do this work, but there should be some training. If the statute doesn't provide for training, we don't want anybody to be doing this if they're untrained. So either we should amend the bill or should bring it back next year.
Yeah, good afternoon. Thank you, everybody. It's the red light automated enforcement that currently has technicians that are permitted to review the images and issue the citations. And the language in the bill before you was pulled verbatim from that section of code. The training from all the law enforcement officers that I've talked with who have done this for their municipality is done by the vendor, and the vendor will not allow those officers to do that unless they take the training to operate their system. So while it's not written into statute, it is in many indications or many instances part of the contract with the vendor.
So you just acknowledge, thank you for coming up and speaking. So you just
Sure.
acknowledge that it's not in statute,
Mhm.
that it's training that's offered by the vendor.
Correct.
Who makes 40% off each of these violations. And the difference being is that a law enforcement officer goes through 7-month police academy and has a significant knowledge base of transportation law and what's required and the elements therein.
Mhm.
Stop, don't stop, red light cameras. So different than where you have speed cameras where you may have more than one vehicle within the influence of the beam. It's different. And until you're trained on that, that training alone just for radar is a couple weeks. So we're talking about this is a speed camera specifically,
Mhm.
and we don't even know what the training is. I mean, I can you speak to that? Because I have a problem with that.
Sure. So having been briefed on what the training looks like, it is reading the computer readout of what the image of what the camera spits out into the system. And it involves a checklist of things to check. That is the date, is the license plate readable? There are 2 videos, one of the car entering the camera zone, one of it exiting to prove that the car was actually moving. And then 2 images, one of the car with a panorama of what the buildings look like around it to make sure that it's the right picture, and then a zoom in on the license plate. And then there is a button to hit submit. Yes, this all looks good. The technician reviewing it doesn't do the calibration on the camera. That is done separately. That's not part of this bill. This is just on the review end, and it is a sequence of tasks within a computer screen.
So when are those done? Because
I gotta move off this bill. I gotta get, so we.
yeah, no, that's fine. I just wanted to say,
No,
I appreciate it.
No, go ahead, finish.
I'm fine, seriously.
Yeah, all right. All right. We will come back to this, but I gotta move on another bill. All right, so, you ready, Jamie?
Yes.
All right.
House Bill 346 establishes reduced penalties for cannabis-related violations of the prohibitions on being a volume dealer under section 5612 of the criminal law article and a drug kingpin under 5-613 of the criminal law article. The bill authorizes certain individuals incarcerated for violations of those sections to file an application for modification or reduction of a mandatory minimum sentence. It modifies penalties and crime classifications for certain firearms offenses and authorizes a person at least age 21 to manufacture a personal use amount of cannabis products or concentrated cannabis as specified in the bill. The bill also specifies in statute that with certain exceptions of a violation involving cannabis, a violation of the volume dealer statute is a felony.
Thank you, Mr. Chair. Just to make this more specific, I remember this bill. Towards the end, I think language was added. It says a person may not possess a stolen firearm if the person knows that it's been stolen, and the penalty is a felony, 5 years and $10,000. And then the second provision is the person may not transport a regulated firearm into the state for the purpose of unlawfully selling it. And that again is a felony, 10 years, $25,000. So the bill is sort of has two elements. One deals with cannabis and the other deals with stolen guns. I think it's important to everybody know that this bill is an important bill dealing with stolen guns.
No, I think it's right. So here's what happened is we sent over this theft of a firearm as a felony. Okay, so we went back and forth about, theft, vice, possession. Obviously, you can't steal something without possessing it, and possession of a stolen firearm is a 5-year felony, 5-year misdemeanor rather. What they've done is they've changed the misdemeanor to a felony because it's easier to prove possession than it is theft. And if you have theft, you've got possession, so it makes sense. So that's what they've done, and they've stripped it off of the other bill that we took off, that we sent over. So this is the only option you have for making possession of an illegal firearm or a stolen firearm a felony.
That was gonna be my next question. Wasn't the stolen gun stuff, wasn't it in a bill that we passed, a Senate bill? They stripped it out and put it in this bill instead.
Be clear, they didn't put it into this bill. This bill, there was that's gonna be in my bill. It's coming back over. It's a whole thing. We're good on that. The FOP thing, I am 100% sure. This is, okay, let me just draw back. A lot of stuff's happened. So they have stripped that stolen theft of a firearm felony piece out of my bill, okay? The House has stripped it out.
Relating to gun buybacks.
Relating to gun buybacks. Remember, we had that Christmas tree, we had the gun buybacks, we had this theft of firearm, then we had, what else? We put trafficking as a felony. What else did we put in there? That was it. Okay, so, and then we had another bill that I stripped that was the cross-file of this bill that it did for the, to fix the FOP problem. Yeah. So they have now put that in my gun buyback bill, taken off the theft felony.
Why are they doing all this?
It's fine. So it's all gonna work. It's just in different vehicles. So thank you for your observation, Senator West. For unraveling all of the stuff that's moving around now. But so that'll be a Senate bill that'll come back here, and I would advise that we concur, or yeah, we concur with what's coming. No, that's not, I didn't make that motion. I'm just saying I'm just saying when it comes back here. Yeah. All right. So the motion for this bill, you got my back, that was good. The motion for this bill would be a favorable. It's been seconded. Senator Carter has a question.
I'm sure what is the minority view, just so I'm clear, we've had this debate for several years about felony, misdemeanor, gun, whatever. And your bill made theft of a gun the felony, no matter what the value of the gun. That was the change. And that was something that I think that made some reasonable sense. Are you saying that this bill as amended makes the possession of a stolen gun without it being a theft of a gun? Are you saying that that is now a felony under this bill, under this amendment?
Right, so under the public safety article, there's an existing provision of law that says, and I'm on page 8. Person may not possess, sell, transfer, or otherwise dispose of a stolen regulated firearm if the person knows or has reasonable cause to believe that the regulated firearm has been stolen. Currently, that's a 5-year misdemeanor. This changes that to be a 5-year felony.
You see what else you're getting in the bill, though?
I see. That's a hard pill for me to swallow. And I know it's the minority view, and I know that most people don't agree with me, but most people haven't been in a courtroom and here, except maybe Folden, most people haven't been in the courtroom and seen someone who had a visitor to their house or a relative who brought in firearms to their home, and then the home was raided, and then the person that resided there, that through no fault of their own, winds up in courtroom. And when you change this from a misdemeanor to a felony, you put the person in a position, where they're not going to be eligible for the same pretrial release and all of the other things. And so this is a problem. And this doesn't require a mental state. It simply says, possession of a stolen gun.
The public defenders are lighting you up right now. I'm kidding.
Honestly, this has nothing to do. I've literally experienced this, and it's unjust. It's already a 5-year misdemeanor, So by putting it to the felony, you up the ante significantly, and I personally have a problem with it. It is not the same thing as theft, and it is not requiring the adequate mens rea for a felony. And you put the person in a situation where you change a misdemeanor to a felony. It's treated differently by the court. It's pretrial, subject to maybe not a release. And you're not even talking about any violent act that's occurred or any attempt to commit a violent act. And for many years, I'm not quite finished, I'm almost done. For many, many years, many years, this body struggled with the that making a distinction between a misdemeanor and a felony, understanding that everything that we are here dealing with when it comes to attempts to modify sentences, attempts to get expungement, attempts to create an opportunity for people to have another chance in life, it is because the stigma and label of felony blocks them from all opportunities of citizenship. And so I do not think this is acceptable, and I don't think that this should be a part of the bill. And that's my opinion. And your bill was already something that we had to digest, but did, and it made a lot more sense. This does not make sense. It doesn't matter that we're getting some reduced penalties on something if we're creating a felony for possession of a stolen gun.
All right, so make a motion for favorable. We can do a roll call.
Vice Chair Wildstriker.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
Pass.
Senator Folden.
Pass.
Senator James.
Yes.
Senator Charles.
Pass.
Senator Kelly.
Yes.
Senator McKay.
Yes.
Senator Carter.
No.
All right, so going back to Senator Sidnor.
No.
Senator West.
I already said yes.
Oh, I'm sorry.
Does he get 2 votes?
Senator Muse. Senator Folden.
Yes.
Senator Charles.
Yes.
Chairman Smith.
Yes. For the Democrats in the room, we've got caucus right now. So that'll conclude voting. We've got caucus right now.